Right. So, as far as you're concerned and your knowledge of the law that you teach, did the Attorney General do anything wrong in writing to the Chief Justice asking for an expedited trial or hearing of the injunction application?
Yeah, thank you very much, Samson. The Attorney General did nothing wrong when he wrote a letter to the registrar or the Chief Justice to abridge the time for hearing the matter. But the question, to put the question that way, would also mean that we have left out some very fundamental, concerns or issues which need to be discussed or need to be considered. There's something called discretion in the Constitution of Ghana. Discretion is very essential to leadership. I mean, if you're in government or if you're a public official, you definitely would need to have some discretion. Discretion is actually the essence of power. So anyone who has power necessarily must have discretion to go one way or the other. So that is the issue on discretion. However, the ultimate essence of law is certainty and predictability. So when, for example, we say the first law of physics or the law of that, what we are basically saying is that there must be, the thing is so certain that it should cut across circumstances and it should apply evenly across the board. So that is the fundamental essence of law. Now, the reason why I'm raising this issue is that the Attorney General definitely has a discretion to abridge or to cause a case, the time for hearing a case to be abridged. And he ought to do that by writing to the CJ or the registrar.
First of all, substantively, there was no time for the hearing. So was there anything to be abridged?
Well, I was going to go to that. And that would have to lead us to the changes in the practice in the Supreme Court. And you remember, I think later last year, there was a directive from the Chief Justice, which indicates that when you file a case, contrary to the previous practice, where you'll be given a specific date on the phase of your motion before the motion even goes out, this time around, we don't have dates on the processes. Rather, there is a note which is often attached indicating that the Chief Justice the registrar would issue a hearing notice. And the note, that statement itself is not clear.
Within 14 days upon service.
Yeah, upon service. And then it says upon request again. So the question is upon whose request, and how would the person who has issued the motion, know that there has been a service on the other party for him to make that request? And if it's supposed to happen within 14 days, then the notice itself is vague. But that is where I was talking about discretion and some of these directives. So the essence of law is certainty, and that's why we have something called constitutionalism. If you have a discretion to do something, the purpose of law is to, as much as possible, limit the discretion so that we don't have some of these things coming where discretion may be exercised capriciously, wrongly, or even vaguely. So what we seem to have here is that we have increased the discretionary power that we are giving in the administration of justice, to the extent that previously, while both parties would automatically know the date of hearing, and then if someone wants it to be heard earlier than that date, we'll make a formal application to the court, which application will be served on both parties, and then the argument will be taken as to whether there should be an abridgment or not, and the two parties are present to discuss or argue that for the court to make an informed decision. Now, the current arrangement actually takes away any of these things. So a person will write a letter to the Chief Justice. The Chief Justice would listen to only that person's concern and either abridge the time or refuse the abridgment. And then at the end of the day, a date is fixed, which may or may not be convenient for the other party. And if it's unable to come to court, the case will be heard So if we talk about whether the AG can do that or has the right or power to do that, indeed, he has the power to do that and it's the right thing to do. However, we have created a system which basically is making it impossible for a hearing to be fair, which is fundamental to our jurisprudence, that whenever a decision is going to be taken, whenever a case is being heard, even every process filed in the case, whether the party is even concerned or not, should be served so that there will not be a situation where a decision will be taken.
So what's the